Let's start with a scenario you might see at the office. Imagine a small boutique hotel in Paris. A tourist from Tokyo books a room online and the hotel processes their credit card details. Now, imagine a software startup in Delhi that creates a fitness app used by thousands of people living in Berlin. Does European privacy law apply to both? This is the core of the GDPR's territorial scope. The regulation is designed to follow the data, not just the physical location of the business. Formally, Article 3 defines the scope based on the establishment of the controller or processor or the monitoring of data subjects in the Union. In simple terms, if you are doing business in Europe or if you are tracking people who live in Europe, the GDPR essentially puts a ring around your operations. It doesn't matter if your servers are in Mumbai or your headquarters are in Bangalore. If you touch the data of people in the EU, you are playing by their rules. It's like a border that exists in the digital world, even if you can't see it on a map. So, now that we've mastered the idea that these rules travel wherever the data goes, you might be wondering how we determine if a company is truly established in Europe. Well, that brings us right into our next step, which is the establishment criterion. Let's talk about what established actually means. It sounds simple, but it is a legal trap. If a retailer in Kolkata has a small marketing office in Brussels, that office is their establishment. Because that office is there, the parent company in India is now caught in the web of the GDPR for all its European operations. The definition is broad. It's not just your main headquarters, it's any stable arrangement where you perform activities like a sales office, a warehouse, or even a local support team. I once saw a tech company argue that because their main servers were in a different country, they weren't established in the EU. But because they had a team of 5 people working out of a shared space in Paris to handle client accounts, the regulator ruled they were fully subject to the law. It's not about where the hardware lives, it's about where the human activity happens. You've probably seen this, where companies think they're safe just because they don't have a giant headquarters sign on a building. But they are missing the point. So, now that we've mastered what makes a business established in the eyes of the law, you might be wondering what happens when a company has no office in Europe at all but still sells to Europeans. Well, that brings us right into our next step, which is the target criterion. This is where it gets interesting for our global businesses. What if you are a completely Indian based company with zero employees and zero offices in Europe, but your website is translated into German, you accept euros as payment, and you offer shipping to Berlin? The GDPR says you are targeting European residents. The definition here focuses on whether the company is intentionally directing its services to people in the Union. It's not about accidental traffic, like a person in Rome happens to find your site. It's about your intent. Do you have a localized domain? Do you run ads specifically for the French market? If the answer is yes, you are targeting, and the GDPR applies to you just as if you had an office on the Champs-Elysees. Stay with me here. I've seen small businesses think they are flying under the radar because they are thousands of miles away, but their marketing materials clearly show they are hunting for customers in Europe. The law looks at your intent, not your address. So now that we've mastered how targeting brings you into the scope of the regulation, you might be wondering about the flip side. What happens when we track someone's behavior without even selling them anything? Well, that brings us right into our next step, which is the monitoring of behavior. We've talked about selling things, but what about tracking? Imagine a weather app developed by a startup in Pune. The app is free, but it tracks the precise GPS location of users in Spain to show them local weather updates, and more importantly, to build a profile for targeted advertising. This is monitoring behavior. The GDPR defines this as tracking individuals on the internet to create profiles, specifically for making decisions about them or analyzing their preferences. If you are tracking someone in Europe to see what they browse, where they go, or what they like, you are under the GDPR's microscope. It's not about a simple cookie that remembers your language. It's about the systematic, persistent observation of a person's life. If your system is designed to follow the user, you are monitoring behavior. This is the reason why so many apps had to change their privacy notices overnight. They realized their tracking features were pulling them into European jurisdiction. So, now that we've mastered why tracking behavior is such a major trigger for GDPR compliance, you might be wondering how this works for third-party service providers. Well, that brings us right into our next step, which is the role of processors. Here is a common confusion. I'm just the service provider. I don't own the data. Many companies think that if they are only processing data for someone else, they can ignore the rules. But the GDPR doesn't let you off the hook that easily. The scope applies to both the controller, the one who decides why the data is used, and the processor, the one who processes it on behalf of the controller. Think of an Indian payroll company that processes salary data for a company in London. The payroll company isn't the employer, but because they are processing the data of European employees, they must comply with the GDPR's requirements for processors. You've probably seen this at the office where a vendor says, "We aren't subject to GDPR because we don't own the data." That is almost always wrong. As long as you are processing that data, the territorial scope applies to your backend activities. It is a shared responsibility that spans borders. So now that we've mastered how the law catches processors in its net, you might be wondering how all these rules are actually enforced against a company sitting in another country. Well, that brings us right into our next step, which is the representative requirement. We've established that the law applies to you even if you're far away. But how does the regulator actually reach you? If you're a non-EU company and you fall under the GDPR, Article 27 says you must designate a representative in the Union. This is a person or a company physically located in an EU member state that acts as your point of contact. If a regulator has a problem with your app, they don't have to fly to your home country. They go to your representative. Think of it like a local legal anchor. It's a mandatory role for most companies targeting the EU that don't have their own office there. I tell all my clients, this isn't just a paper pushing exercise. It is a critical piece of your compliance architecture. Without a representative, you are technically in breach of the law from day one. You have now moved from the theory of territorial scope to the practical reality of how to set up your legal presence. We have covered the establishment, the targeting, the tracking, the processors, and the representative. You now have a very sharp professional lens for evaluating which of your projects are subject to European law.